estate estate planning mistakes. We're going to record this for everybody's benefit too, and anybody who misses it, they'll be able to listen to it. Um, there are 10 mistakes that we're highlighting, but there are probably 100 that we could talk about. And many of them are subsumed within each of these 10 categories. The first mistake that we'll call mistake number one is what I refer to as the improper use of jointly held property. Too much joint property. When property is titled jointly, there's a potential for double taxation, believe it or not. And then there's survivorship issues. And so we're going to dig into each of these categories. On the double federal taxation issue, this is how it works. If you have joint ownership between individuals who are not spouses, so a parent and a child, for example, the entire property is going to be taxed in the estate of the first joint owner to die, except to the extent that the survivor can actually prove that they contributed to the ownership of the property. Then, whatever the survivor receives and doesn't spend or give away is going to be included in the survivor's gross estate. And with non-citizen spouses, you've got the added complication that the marital deduction may or may not be available depending on whether or not you use what's called a qualified domestic trust. So that is an important issue to think about if you want to do everything in joint ownership. Next issue under mistake number one in terms of joint ownership is that once jointly owned property with a right of survivorship has passed to the survivor, the provisions of the decedent's will, who owned the property in joint ownership, are ineffective. A will is ineffective as opposed to a joint and survivorship designation on property. So you can say anything you want to in the will about a jointly owned piece of property, but the jointly owned survivorship property passes to the survivor regardless of what the will says. So it's left outright to the survivor, who's then without the benefit of management protection. They don't have the ability to get the same investment advice, perhaps, and the property could be left to somebody that the original owner or co-owner didn't anticipate leaving it to. Think about it this way. You're married to somebody and you own the asset as joint tenancy with rights of survivorship. And let's say that property was acquired after the parties had been married previously. So it's a blended marriage. One party has kids from a first marriage. Another party has kids from a first, second, third, or fourth marriage. They get married. They title the property jointly, so it goes to the surviving spouse. You as a co-owner, perhaps unintentionally, are giving the surviving spouse the right to shift the asset to somebody completely outside of your estate plan. So that is a huge, I think, mistake or potential mistake in terms of owning joint property. And the surviving spouse basically can give away during lifetime, if they acquired the asset, or at death, the formerly jointly owned property to anyone the surviving spouse wants. Charity, the new boyfriend or girlfriend or new spouse. So it's always something that you need to take into consideration when you're doing joint assets. And then lastly, under mistake number one, joint assets, since the property passes directly to the survivor, who might squander it, gamble it away, give it away, or lose the property to creditors, the decedent's executor could be faced with a lack of adequate resources, cash, to pay estate taxes or other settlement expenses, that because the asset passes automatically to the survivor, those assets are out of the estate and cannot necessarily be attached by creditors or by the IRS or state and local governments. So watch out for joint property, bottom line. Mistake number two, in the top 10 mistakes that people make in estate planning. And there are 9 subcategories that revolve around the ownership of life insurance. The one that I always worry about with my clients, and you should worry about with yours or yourself, is do the proceeds of the life insurance get paid to a beneficiary at the right time or at the wrong time? And are they paid to the wrong person or the right person? In other words, is the individual physically, mentally, emotionally, or legally able to receive the life insurance proceeds? I'm sure you know that if you leave a child as a beneficiary of a life insurance policy, even if it's a contingent beneficiary, second down from the primary beneficiary, if you name an individual as a beneficiary of a life insurance policy and they're under the age of 18, or they're in any way disabled so that they qualify for governmental benefits, you may destroy their ability to receive that governmental assistance, or they may not be legally capable of even receiving the asset. Number 2, inadequate insurance on the life of the breadwinner or the business associate. What does that mean? Well, you need to make sure that you've got life insurance not only to cover contingencies like mortgages and other expenses. You want to make sure that the survivor, the surviving spouse in many cases, has enough assets to live on after you're gone, because your income generating capability may have diminished. Number 3, a lot of people will get life insurance. They'll immediately name a parent or a spouse or a girlfriend or somebody, a boyfriend, as the beneficiary of the policy. But if that person is no longer in your life or they're no longer living, have you named a contingent beneficiary, a backup? Have you named 2? I always go with the rule of 2. The rule of 2 says if you've got one person named as a beneficiary, name 2 more as backups. And oftentimes it causes delays in finishing estate plans. It's not just on life insurance, it's on your trusts, on your wills, on your other documents where property is transferring at death. Number 4, proceeds of the insurance, most people forget about this, are included in your gross estate for estate tax purposes. So while you may have assets under the exemption that's currently available of $12,060,000 per person per lifetime, if you add in the insurance, it may kick you over that level. And by the way, the exemption drops at the end of 2025 by half. So the proceeds of life insurance are includable in the gross estate of the insured because the policy is owned by the insured and either never was transferred or was transferred within 3 years of the insured's death. There's a special rule that causes the insurance policy, even though you transferred it before you died, to be added back to the estate if it was transferred within 3 years of death. There are lots of solutions, including using irrevocable life insurance trusts to avoid this result. Number 5 on the insurance top 9 is you may have a gift from the policy owner to a third party on the death of the insured. What do I mean by that? When a policy owner of a policy on the life of another names a third party as a beneficiary, at the death of the insured, the proceeds are treated as a gift to the beneficiary from the policy owner. Let me give you an example. Mom purchases a policy on her husband's life. She's the owner of the policy. The husband is the insured. And she names the kids as beneficiaries of the policy. If husband and when husband dies, wife is treated as making a gift in the amount of the proceeds to the kids. Bet you didn't think about that. So how you own the policy, again, very important. Number 6 is a really complicated area of tax law. It invokes both gift and estate taxes, but also income taxes. And there are special rules that apply to corporations. So let's say you have a corporation and you go out and have that corporation buy a policy of life insurance on one of the owners of the company. If the corporation names somebody other than itself or a creditor, which is where this often comes up, as the beneficiary of insurance on the life of a key employee or a shareholder, when the proceeds are paid, the IRS is going to try to argue that the proceeds are not income tax free and should be treated either as dividends in the case of a shareholder or as compensation in the case of the employee who's not a shareholder. Worse yet, if the insured owned more than 50% of the stock of the company, he's deemed to have incidents of ownership, which means that it gets dragged back into his estate even though the corporation owns the policy. So for example, let's say I bought a policy that was $1 million on my life, but I bought it in the corporation and I own 51% of that company. It could be taxed as a dividend to me for income tax purposes and subjecting it to tax on the proceeds that are received at death. Number 7, subjecting the proceeds to the claims of estate's creditors. Now, if you structure life insurance ownership properly, you should be able to avoid your creditors. For example, use an irrevocable life insurance trust to own the insurance policy. When the proceeds get paid in on your death, your estate's creditors don't have a claim against that policy in the trust absent fraud. So by having it paid to your estate, not naming a beneficiary, for example, or not naming a contingent beneficiary, and the first beneficiary dies, so there's nobody to receive the asset on your death, it goes into your estate. It not only gets subject to estate tax potentially, it also is subject to potential claims of creditors, and it's subject to probate, which is something we try to avoid at all costs by using revocable trusts and insurance trusts. Number 8, the transfer for value rule. Now, there are exceptions to this rule, and we're not going to talk about all this stuff in detail today because it's way too complex. But if a life insurance policy or any interest in a life insurance policy is transferred for money or any kind of value, the proceeds may lose, not will lose, may lose their income tax-free status. For example, let's say your child buys $1 million term insurance policy on your life, and they buy it from the corporation or a business partner, and when the child receives the proceeds, the entire $1 million could be subjected to ordinary income tax. Again, there are exceptions to avoid this, but you've got to be careful in how you structure the ownership of the insurance. And so the goal is to qualify for an exception from the transfer for value rule and not fall into its trap. Lastly, number 9, again, failure to update your beneficiary designations when an estate plan changes. Let me give you an example. I had the occasion of representing somebody many years ago. His estate came to me after he passed away, and he changed his life insurance beneficiary designations and his retirement plan beneficiary designations the day before he committed suicide. He changed the designations and mailed them into the insurance company and to the retirement plan provider. Needless to say, the beneficiary designation changes were received after he died. The insurance company and the retirement plan administrator was refusing to honor the beneficiary designation changes because even though he signed them before he died, they didn't receive it until after, and they had no real evidence because it wasn't notarized that he did it before he died. So he ended up having to leave his life insurance policy of millions of dollars to an ex-partner. And they had broken up months before, which may have led to his suicide. A horrible result. We ended up negotiating a settlement with the partner so that fairness could be achieved, so that the right beneficiary could at least receive most of the proceeds. But these are things you need to watch out for. These are mistakes that are commonly made in estate planning. The third category of mistakes, I'll call it mistake number 3, is choosing the wrong executor or the wrong trustee. The person who administers an estate or trust is required by law to, with dispatch, quickly, often without compensation, with great personal financial risk, and without conflict of interest, collect all the assets of the decedent, number 1. Number 2, pay all of the estate's obligations and the decedent's obligations, which carry over to the estate. And 3, distribute the assets among the beneficiaries. This 3-step process sounds so simple, but if any of you have gone through any kind of estate administration or even trust administration, you know that it's much more complex. So one of the first errors in this area is choosing the wrong person to serve. Invariably, in almost every estate planning consultation, the family wants to keep the designation of who the executor is or the trustee within the family unit, maybe the immediate family or brothers or sisters or somebody somehow related to the family. And there's some common sense behind that, because generally you can trust these people to do the right thing, right? You can trust your brother to do the right thing by your kids. You can trust your sister to do the right thing for your mother, if that's who your heir is and that's who you've named. But if the brother or the child is named as a personal representative or executor, and they're also a beneficiary under the document, it's a potential conflict of interest, meaning that they want to look out for their personal interests, and at the same time, they want to look out as a fiduciary for the interests of all the beneficiaries. Well, if they're appointed as a trustee or executor, their first responsibility and primary responsibility is to all of the beneficiaries. Let me give you an example of one situation that I came upon many years ago, not that many years ago, but a decade ago. A friend of mine came to me and she said, I'm one of 5 kids. And my brother was named as the executor of my grandma's will. And the 5 kids, the grandkids, were named as the beneficiaries. They skipped over the parents. The guy that was named as the trustee came in, gathered all the assets like he was supposed to, paid all the obligations like he was supposed to, but did not distribute the assets like he was supposed to. And the heirs, the other beneficiaries who were co-beneficiaries with this guy, contacted me and said, what do we do? I said, well, you could sue him for breach of fiduciary duty. Well, I don't want to do that. It's going to create a rift in the family that will never be repaired. Well, sometimes you have to consider that. But that's where you run into potential conflicts, is where you have somebody doing the wrong thing and not necessarily knowing what the right thing is. So obviously the best thing to do is to consult with your attorney, your estate planning attorney, and make sure that the beneficiaries you're choosing, if you're going to choose a beneficiary to serve as a trustee or an executor, aren't going to do the wrong thing. And the same thing for a business associate. Let's say you've got a business and you own 100%, and you trust your business associate to be the trustee to manage the business after you're gone. Well, the business associate may be an employee of the business, And that business associate may not be very inclined to sell the business if they're going to lose a job in the process. So think about conflicts of interest in addition to who might be the best person to serve. Lastly, on this mistake number 3, the choice of executor, I've seen this happen time and time again. And we've actually been involved in litigation on behalf of a beneficiary of an estate where an executor was named, came in, and just didn't do anything. They sat on property. I'll give you an example. We have a case. Names will go unmentioned, and we'll change the names to protect the innocent. We're involved in representing a beneficiary. I've done this several times before, where the beneficiary comes and says, my sister was named as the executor of my father's will, and he held a bunch of real estate. And in 2 pieces of real estate, my sister lives in one, and her kids live in another. And I said, well, you own 1/3 of that real estate according to the will. It says that each of the siblings, 3 siblings, gets 1/3 of the property. Well, what are his rights? His rights were to demand that the sister administer the estate properly and divide the properties properly and vacate the property if she's occupying it or pay fair rent, so that the other siblings are compensated for her use of the property and her kids' use of the other property. She refused to comply. We had to sue her in a partition action because it was treated as tenancy in common property. And any tenancy in common owner has the right to force a sale of those properties. And we're in the middle of finalizing the litigation in that context. It happens. So they may lack the expertise, they may lack the time, and they don't spend time on it. They don't want to spend the energy on it, but at the same time, it takes energy and it takes time. And they should be entitled to compensation, and that also raises the hackles of the siblings or the other beneficiaries because they don't necessarily want to have to pay a sibling to administer the estate because they'll say, I'll do it for free. Not always the case and not always a wise decision. Living outside the state of the decedent's residence. In Florida, you must have either a resident executor, also known as the personal representative, or a close family member. I had to serve as a trustee and an executor for my sister's estate. It was in Florida, and I was named as the executor. Of course, I don't live in Florida. She did. And because I was a close relative, I was able to serve under Florida law. In Virginia, the rule is you can appoint an in-state resident executor to serve as a co-executor with a named resident who's out of state. If you don't do that, you may have to post a surety bond with the court in order to ensure the faithful performance of the executor's obligations. So from state to state, the laws vary, and you have to be advised that maybe having a resident executor is an important point to consider in doing your estate planning. And then lastly, bringing in somebody who doesn't have a relationship with the heirs to serve as a trustee or an executor can be problematic if they don't know the family dynamics, which is one of the reasons why with our clients, we try to have family meetings well before anything bad happens so that the parents can introduce the children to the attorneys who can then develop a relationship with the children if we are going to serve as a trustee, or to at least advise the children who may be serving as a trustee themselves. So having somebody who does have a relationship with the heirs or the beneficiaries is an important way of avoiding this mistake. Remember, you can have more than one trustee and more than one executor in an estate. So you could have a family member serving with somebody else as a co-personal representative, executor, or trustee. And then both may have to reach decisions on important issues such as investments, distributions, and the like. Mistake number 4. Creating an invalid will or will with errors. This is one of my fun areas to talk about because we have a lot of clients who think that they can either do it themselves. Had several over the last couple of months come in with do-it-yourself internet wills done through LegalZoom and the like. And I'm not bashing LegalZoom, by the way, because you can go on to LegalZoom and be connected with an attorney through LegalZoom to advise you. The question is, do they have the level of expertise that you need in order to devise your estate planning? I think that's where you run into some roadblocks on using those services. But if you use Willmaker or any of the other online services where you download a will, or you download a trust, or you download an LLC and you prepare the documents yourself, you're going to run into some issues. And the issues are, you may think you know what you're doing, but you may not know what you're doing when you're doing it. Number 1. Number 2, you may not properly execute the document in accordance with the state laws. So, for example, some states require 2 witnesses who are physically present with the person signing the will at the time they sign it, along with a notary. Other states are allowing remote notarization. So you have to know what the rules are in the state where you're executing the documents. Number 2, holographic wills. What's a holographic will? Well, it's a basic type of will that is handwritten. Can't be typed. A holographic will is not typed. It's handwritten. It's signed and it's dated. That's the general definition of a holographic will. Is it enforceable? In many states it is. Virginia, it's an enforceable will as long as it's executed properly. And then the question is, if you hand wrote a will, did you know what the heck you were writing? Highly doubt it. I haven't seen any holographic will that doesn't have a defect of one sort or another. So not a good idea to handwrite your will or to create a codicil to your will using a handwritten document. You need proper execution. And that's the next point on this. Properly executing the will, properly executing the trust. Did you know that an advance medical directive in Virginia has to be witnessed by 2 independent individuals who are not, at least one of whom is not related to you? And it has to be notarized. So depending on the state, you want to make sure your documents are properly executed. Again, we talked about out-of-state executors a second ago. No need to belabor that point. What about naming an heir who is a niece or a nephew in the will, and you decide to leave an asset outright to that niece or nephew, but unbeknownst to you, you don't have much of a relationship with them. They qualify for governmental assistance. And if you left the asset outright to them, have you just destroyed their ability to continue to qualify for governmental assistance? Or did you have some kind of protection in the trust or the will to avoid that result? Creating an invalid will or will with errors is dangerous. I'll give you the final example. And this is an example I use all the time. This must have been around 1998. I was in practice by that time for 13 years. So I've been practicing a long time. Still haven't gotten it right yet, but I'm practicing. And in 1998, we had a situation come to us at our law firm from a very prominent individual who was the daughter of a very prominent individual that passed away, a very famous individual. And the daughter brought the will to us and she said, you know, something's wrong about this will. I know my dad intended to leave some money to the National Historic Preservation Trust in his will. And there's a mention of it in here, but it doesn't really say that. Do you agree? We looked at the will, 5 minutes. We could say it didn't have a proper residuary clause. It was a huge error. It was drafted by a prominent lawyer in Montgomery County, Maryland, again, who will go unnamed. We had to, again, file suit to have the will construed. The court basically found what we saw, and that was an invalid will. Then the charity proceeded to sue the lawyer. We ended up settling everything out of court. But the idea is that you want to be really careful that you're naming beneficiaries of the will or trust, and that you've thought about the eventuality that a beneficiary may not be there. What happens to their share if they're gone? So that's thinking through the document carefully so that you avoid errors. Mistake number 5, leaving everything to your spouse. So people often focus on the estate tax and they say, you know what? I don't want to have to pay estate tax on my death. So I'm going to leave everything to my spouse outright. Of course, if you owned it jointly, it goes to the spouse anyway. And if you leave something outright to a spouse or in joint ownership with rights of survivorship or tenants by the entirety, which is the married form of joint ownership with survivorship for spouses, it automatically passes to the surviving spouse either under a will, a trust, or by operation of law or contract. And you don't have to worry about the estate tax on the death of the first spouse. But on the death of the surviving spouse, people forget that everything that the surviving spouse has received, assuming that they haven't consumed it or given it away or blown it, is piled on top of their assets to calculate what the spouse owns for estate tax purposes. And again, the exemption is high. It's $12,060,000 in 2022 per person. So a married couple can shelter over $24 million of assets and not have to worry about the estate tax until 2025, when it drops by half. And then all of a sudden, 25% of the U.S. population is subject to estate tax at that point in time. But again, not just dealing with the estate tax is a reason to examine how you're leaving assets to the spouse. In other words, how do you protect the assets for your kids or your grandkids who are your heirs? If I left everything outright to my spouse, and my spouse goes out and gets remarried, I know that my spouse is not going to do anything untoward, but the new spouse who comes in might. Again, think of that blended family situation. And I've seen this happen dozens of times, by the way. We do the estate planning for the widow or the widower, and a new spouse comes into the picture. And the estate planning that we had done left the assets in a nice buttoned-down trust for the kids and grandkids. They get remarried. The new spouse convinces the first spouse to retitle all the assets as joint ownership with rights of survivorship. And by the way, the new spouse has kids from a prior marriage. Those assets are no longer protected for the kids from the first spouse's earlier marriage. And so we want to think about establishing a trust, a marital trust, for the benefit of the surviving spouse, who may be a new spouse with a blended family, and having it dictate what your wishes are. The second issue along these lines outside of taxes is, does the surviving spouse know even how to manage these assets? If we put the surviving spouse in charge of the assets because we've given them to them outright in the will, trust, or by joint ownership, are they best able to manage these assets? And who do they trust and who can be trusted? Whereas you could lay out the framework using a marital trust or even a credit shelter trust to provide assistance to a spouse who may not be comfortable doing it himself or herself. And then lastly, structuring estate plans that take into consideration maybe maximizing estate tax savings, but aren't considering the fact that there may be generation skipping transfer tax imposed on distributions from a trust to grandkids or beyond. You want to build in the planning And if you left everything to the spouse, we may not be able to have taken into consideration the exemption that you get from generation skipping transfer tax, which is imposed at a rate of 40%, by the way, in addition to the estate tax, unless you qualify for exemption. Well, unlike the estate tax where you can carry over an unused exemption, the GST exemption expires at death if it's unused. There's no portability of the GST exemption, which is why using trusts to take advantage of the exemption is really important. Number 6, mistake number 6, failing to complete and implement your estate plan. You've got to have the right team involved. Some of my team members and some of my estate planning are on this call today. And I really rely on them to help us do our job correctly. We'll talk about that in a second. Funding the trust that you may have created to avoid probate before you die, and really while you're competent to do so. And then, of course, dealing with the blended family situation. You want to have the right team involved in managing your estate. And if your wealth is significant enough, having this team is absolutely critical to doing the right thing for your estate, for your family, for your heirs. That team consists of a CPA, somebody who's going to be involved not only with your income tax planning, but also your gift and estate tax planning, working in conjunction with your attorney. And I put attorneys on here because oftentimes one attorney is not enough. You may have a corporate lawyer who's helping you with your closely held business stuff. You may have only an estate planning lawyer who's helping you with your estate planning stuff. Or you may have the family lawyer who does a little bit of everything. Watch out for those guys and those women. A little bit dangerous to put all your eggs in one basket. But the attorneys are critical in this process, as are life insurance agents. And of course, the CFP, who often serves as the quarterback, certified financial planner or financial advisor. Financial service professionals usually have a great picture of what your total asset base is. They're helping you, hopefully, with your financial planning so that your assets outlive you, and they can be the coordinators of this program. Oftentimes, the attorneys want to do that as well. So does the CPA. It's finding people who can put their egos aside to be able to work as a team member collaboratively and cooperatively. Really, really important. Funding, part of this failure to complete and implement your estate planning. Well, if you've worked with us, you've done a revocable trust. Why? Because you want to avoid probate. That's the number one reason. Probate in Virginia is the process through which assets have to move if they are not passing by beneficiary designation, by operation of law, or through a revocable trust. If they pass by will or intestacy, you got to go through probate. And in Virginia, you have the added complication of having to pay a probate tax on the value of assets passing through probate, and you get the privilege of paying the commissioner of accounts in whatever jurisdiction you resided in, not you, but your executor, has to pay the commissioner of accounts a fee to audit your inventories that you have to file and your accountings that you have to file. And after all is said and done, you may be ending up paying 2 to 5% or more of the estate value in fees to administer probate. You can avoid that by getting your assets into your revocable trust either during your life or by operation of law at death. What do I mean by that? Let's say you absolutely don't want to open up a new bank account. You've got a joint bank account at XYZ Bank, and you want to keep it that way because that's the way you and your spouse have lived all your lives, and you're going to keep that joint bank account. The question is, what happens if something happens to one of you? If one of you becomes incapacitated, not a big problem. What happens if one of you dies and the other becomes incapacitated in a joint account? Well, if you have a power of attorney, whoever you've named as the backup power of attorney, they should be able to help you. What happens if both of you die and you haven't named a transfer on death or payable on death beneficiary? You need to do that to avoid probate. So funding irrevocable trust is either putting your accounts in your trusts, which I prefer, or naming a transfer on death or payable on death beneficiary, and making absolutely sure that you have a power of attorney in place with somebody that you can trust who can serve as a fiduciary, as an agent over your affairs if you became incapacitated and you haven't moved the assets into your trust. Some estate planners are better at convincing you and your clients to finish their estate plans than others. We're really good at that. We push our clients to fund their trusts and make sure that they're done. And if you want to participate in an ongoing basis, we offer a membership plan to allow you to do that. It's a matter of inertia. Once the client starts, we have to keep going until we're finished. That's our philosophy, and we're not going to let you go until you have convinced us that you've taken the proper measures to fund your trusts. We want you to hire us to do that if you won't do it yourselves. And then lastly, tough choices with blended families. This is where you get into the question of, well, do we combine our assets into a joint trust, let's say, or do we keep them separate? Oftentimes when there's inheritance coming from one family or another, the family receiving the inheritance wants to keep the assets separate, not because that they're going to cut the spouse off from access to those assets, but because they want to ensure that whatever's left over after both spouses are gone is held for the benefit of the kids. So that's why keeping them separate may make sense, and using revocable trusts makes even more sense. Then the question is, I've got a kid from marriage number one, we have two kids from marriage number two, and then together we have a family together where we had kids ourselves. How do you divvy up the assets? You need to think about that before it's too late. And it's a tough, tough decision. Not an easy thing to think about. And there is no, well, what do you recommend? Or what do your clients do? You can't do that. It doesn't work that way. You've got to have an individual discussion with every client. Facts and circumstances are different from every client to the next. Okay, so that's failing to complete the estate plan. We're rounding the bend on the top 10 mistakes that people make in their estate planning. And I got to tell you that this next one, number 7, failure to provide complete and accurate information to the estate planner, is one that we experience a lot. Remember this from Jerry Maguire? So, withholding information. Whatever the reason is for withholding information, it depends on the individual. Some people are very private and they don't want anyone to know what they have under any circumstance. And so they won't disclose everything that they've got, and they keep things close to the vest. Maybe the client thinks that the information is too embarrassing, or it's going to give too much financial information that will alert the taxing authorities to something that you may have done that was improper. Or maybe they don't trust the estate planner or the financial planner enough. Whatever the reason, it's the wrong approach to withhold information. It leads to mistrust. It leads to incomplete planning, which can create potential problems down the road. And if there's no transparency, not only between the partners or the spouses, which often becomes an issue, or between the client and the financial planner and the estate planner, it becomes really difficult for us to render good advice. Whatever the reason is, we've got to get all the information, because the more information we have, the better we can help you, not just in terms of tax planning or financial planning, but in terms of planning, figuring out the right way to distribute assets or hold them in trust for the benefit of the heirs. We talk about each individual individually. We talk about them, each child individually. We want to know the story behind each of your kids, behind each of your grandkids, any potential heirs, brothers, sisters. Do we need to set up a special needs trust for them? Do we need to hold the assets in trust longer? If we do something for one beneficiary but not for the other, is it going to create a rift in the family? All of these things are important to know when we're doing your estate planning. Joint representation. A simple word about that. When we represent a husband and a wife, you'll see in our engagement letter that says that's a potential conflict of interest, right? Because the husband and the wife, or the husband and the husband and the wife may not be totally aligned in how they feel about things. And so we want to make sure that if both of you hire us to represent you, you're waiving the potential conflict of interest. And if you get divorced, we can't represent either one of you without the divorce being completed and then waivers being executed by both parties after that. And each state is different in terms of its legal ethics as to what you can or can't do. So it is a potential conflict, and we've run into this many times because the divorce rate in the United States, according to ABA studies, American Bar Association studies, is over 50%. And so when you're dealing with that level of change in the marital relationship, it's really important to understand what joint representation means and what it doesn't mean. By the way, if we represent both spouses, we have to give information from one spouse that's conveyed to us to the other spouse and vice versa. There's no secrets. Omitting information is the last thing which we talked about. Again, full disclosure, full transparency is absolutely critical to a successful estate plan and estate planning relationship. Mistake number 8. Really common mistake that's made is the incomplete or incorrect beneficiary designations. And this has become even more important after the passage of the Secure Act in 2019 during the Trump administration. In that legislation, they predominantly did away with inherited IRAs. So a spouse can roll over an IRA from another spouse. They can even inherit an IRA. And a child can inherit an IRA, but if they don't satisfy certain criteria, in most cases they don't, you have to distribute out that IRA within 10 years of becoming a participant. And there's no exception to that rule unless you meet one of the few exceptions, like for disability or for minors. So you want to make sure that the beneficiary designations have been thought through. When we do revocable trusts for our clients, we design a beneficiary designation form that can be attached to a 401k or an IRA that deals with the individual's specific estate planning situation. Do they want the asset to be distributed out based on the life expectancy or, in this case, the 10-year period? Do they want it to be held in trust and accumulate but be taxed at trust rates, which are much higher than individual rates at a much lower income level? So these are all considerations that we use in creating beneficiary designations. But there's so many horror stories, and I've given you a couple already, about not having correct beneficiary designations or complete beneficiary designations. Remember the rule of twos, really important. We need beneficiary designations for life insurance. We need a primary and a contingent or secondary or a tertiary contingent beneficiary. We need them for non-qualified plans as well as IRAs and qualified plans. We need them for tax-deferred annuities, and we should have them for jointly owned assets if we're not going to put them into a trust. And are they current? And how often are you checking these beneficiary designations? And are they going to the right people at the right time? That's a question. Lastly, again, do you want your child to receive $1 million life insurance policy at the age of 18 or even 25 for that matter? Are they ready? Are they able to receive that? Are they going to give it away? Are they going to buy a Ferrari? Maybe the Ferrari's going to appreciate in value, but any other car might not. Are there backups? Rule of twos. Number 9. This is really important. Failing to plan for incapacity is a potentially fatal flaw in estate planning. What do I mean by that? Let's say you own a house with your spouse. Tenants by the entireties in Virginia. And on the death of one of the spouses, it automatically goes to the surviving spouse. No problem. What happens if one of those spouses becomes disabled or incapacitated and you need to sell the house? You have to go into a conservatorship proceeding. In Virginia and other states, Florida, you would have to do the same. Do you want to go through that? You can simply avoid this by titling the assets properly and having the right documentation. Using a revocable trust as well as a power of attorney can overcome some of the flaws in failing to plan for your own incapacity, particularly with respect to real estate. And with clients who own real estate in multiple jurisdictions, you also want to avoid the issue of ancillary probate. So you want to get your real estate either into revocable trusts or LLCs or some other vehicle that can avoid probate. Do your documents adequately address incapacity? Are they dealing with the situation where you've got dementia, Alzheimer's? Do you want to be put in a nursing home or do you want 24/7 care at home? Can you afford it? Has your financial plan been updated to tell you whether that's the case? Do you have long-term care insurance to deal with this issue? And how is incapacity determined? We do it a variety of different ways for different clients, but our usual way is have a couple of doctors, 2 doctors, one of whom is your attending physician or your family physician whom you trust. Certify in writing that you are no longer able to manage your financial affairs. At some point in everyone's life, they may come to that conclusion, and they don't have to be determined to be incapacitated. They could just pass on the mantle to somebody else. But if you are incapacitated, you cannot amend your will or change your trust if you're truly incapacitated. And the goal, again, a conservatorship proceeding, that requires you to go to court. Probate requires you to go to court. So stay out of court if you're incapacitated. And are these documents coordinated and up to date? Many financial institutions are now requiring powers of attorney to be updated annually, believe it or not. We haven't run into that problem with our clients because our financial powers of attorney are so comprehensive, but it's not a bad idea to have them reviewed periodically, at least every couple of years. The last mistake is the most important one. We're relying on somebody to do the right thing when we appoint them as an executor or a trustee. If we don't appoint them as executor, that's even worse. But if we appoint them as executor, but we haven't given them specific guidance on what to do, like over on the slide, it says, I leave my estate to my wife, to my partner, to my daughter, and decide whatever to give to my kids, my grandkids, my siblings. Well, by doing that, you may actually be putting the executor or the trustee into a gift tax situation where they, because they are deciding over the assets, they have the power to transfer the asset to somebody that you didn't name You didn't do the right thing by them because now they have to use their annual exclusions and their lifetime exclusions to absorb the gifts that you want them to make for you. And that's just bad planning. And what if you leave it up to somebody to do something and they don't do the right thing? So it's naming the right person to do the right thing and doing the right thing by giving them sufficient instructions in the documents so that they know what to do after you're gone. Now, I got so excited about doing this presentation that I forgot to do some polls that I was going to do. And so let's do some of these polls. Get back in the picture. Everybody's texting me. Okay, I'm in the picture. Let's do this. I want to ask you a couple of questions and see if you've got some answers for me. Here we go. Tell me why you're here today. Why did you join us today? Did you join us so that you could advise your clients properly? Did you want to make sure your estate plan is correct? Are you pretending to be on the seminar so you can shop online? So far, nobody's answered that one. We've got a bunch of responses coming in. I'll give it another minute or so. Have a little fun with you. This will also tell you the makeup of most of the people on the presentation today. And here are the results. Almost 3/4 of you want to advise your clients properly. And the rest want to do it the right thing. They want to make sure that your estate plan is correct. Next question, next poll. So you listened to me talk, I think it was item number 3. How can you create an invalid will? Can you create an invalid will by doing it online? Moving out of state? Signing it online? Or all of the above? Some people are thinking about this. Almost everybody's on yet. Not everybody's answering. Oh, here comes a late one. And 5, 4, 3, 2, 1. "14 out of 17 answered, 82% answered that any of those things can create an invalid will, and that's correct. But doing it online, you could also create an invalid will. Moving out of state, potentially, not always, but could. And then signing it online in most states would create an invalid will. Let's do another one. You guys are getting the hang of this. What happens if you fail to disclose your entire financial picture to your estate planner or your financial planner? The planner may make a mistake in calculating the estate tax. The planner will not find out confidential information about me that I don't want him to know. The planner will not be able to inform on me to the IRS or my family if I did something illegal. And the planner will double my fee and claim my firstborn child as collateral. It seems like everybody is really focused on the estate tax. And you know, somebody answered, you'll laugh at this. The last one The planner will double my fee and claim my firstborn child as okay, that's a joke. But the planner will not find out confidential information about me that I don't want him to know. Well, that's true. That is true. But they may make a mistake in calculating estate tax exposure, which I've seen happen more likely than not, or more often than not. Some folks are dropping off as we're doing this, and I want to have some Q&A if there's any Q&A to be had. Lastly, what did you get out of today's Lunch and Learn? Did you get anything? If you got nothing, tell me, because that's important to me. I heard the word mistake repeated a bunch of times, but I don't remember anything discussed. Number 3, several things. I need to revise my documents. And then lastly, nothing, because Zell Law prepared my estate documents and they're perfect. Well, that's really nice. If you said that, thank you. We greatly appreciate your patronage. Last question is, here's the results. Somebody was shopping online. A bunch of people need to revise their documents, which we're glad to hear, and we're here to help you. If you need us, give us a call at 571-203-9355 or visit us on the web and sign up through there. We've got tremendous web presence. And lastly, thank you for those who gave us the kind words that we think everything's in good shape. Are there any questions, Kat, that anybody has? Or if you have any questions and you want to send me a chat with a question that you've got before we sign off today, let me know. We'll wait for you to type in a question or two, because we'd love to hear from you. And if you've been multitasking, that's okay. Go ahead.
I was going to say no questions were shared with me.
Oh, come on. Come on. Come on. Really? No questions? Don't wait too long. Okay, we're not going to wait too long. All right, so to get your CFP credit today, we're going to give you a code. It's very simple.
Oh, wait, we do have one question.
Oh my gosh. Go for it. What's the question?
When is irrevocable trust come into play versus revocable trust?
Good question. An irrevocable trust can be used for a variety of purposes, but predominantly they're used to shift wealth out of an estate during your lifetime. So you'll create an irrevocable trust, a lifetime irrevocable trust, to move assets into trust for the benefit of a spouse or heirs or kids or anybody that you want to benefit. So that's when an irrevocable trust is set up. A revocable trust is usually set up during your lifetime to minimize the exposure to probate, to plan for incapacity, and also to be portable if you're going to be moving from state to state. But you can change a revocable trust at any time. An irrevocable trust is much harder to change. Now, there are ways of changing irrevocable trusts, as many of our clients know. There's something called decanting. There is a way of reforming trusts. There are many different ways of changing an irrevocable trust. And then lastly, there is the ability to do an irrevocable trust at death. In fact, when you die, your revocable trust becomes irrevocable at that time. And then it can't be changed. Like a will, it's a will substitute. So we use them for estate planning purposes, for gift tax planning purposes, for generation skipping transfer tax planning purposes, and for asset protection. Because a well-drafted, irrevocable trust with independent trustees can yield tremendous asset protection benefits that will prohibit the beneficiary's creditors from reaching those assets. And so the asset protection side of it, as well as the tax protection side of it, are two real good reasons to do irrevocable trusts while you're living, or again, upon death, the revocable trust becomes irrevocable at that time. Any other questions today?
I do have another one for homes owned jointly with a spouse. Does it always make sense to put it into a revocable trust?
Okay, I'll give you the Virginia version of it. I'll give you the Maryland version of it. I'll give you the DC version of it real quickly. The answer in Virginia and Maryland is it does make sense. And the reason why we would do it is if we have first titled the property as tenants by the entireties in Virginia or Maryland, we get super asset protection that we wouldn't get if it's held just as joint tenancy with rights of survivorship. So that's step one. Then you can take a tenancy by the entireties property and move it 50-50 into your revocable trusts or into a joint trust and retain the asset protection. What do I mean by that? If somebody sues one of the spouses in that scenario, they can't split the asset apart. They can't get at the asset. It's asset protected. Whereas if we own it as joint tenants with rights of survivorship and we haven't specifically designated as tenants by the entireties or moved it from T by E into the trusts, we don't get that asset protection. They can split the asset. The other reason is if it's held in revocable trusts and instead of tenants by the entireties or joint tenants, the co-tenant, if they're a trustee of the other person's trust, can do anything they need to do, refinance the property, sell it, lease it, whatever, without having to go to court. If you have tenancy by the entireties property and you haven't moved it into the revocable trusts and one of the spouses becomes incapacitated, the other spouse, in most cases, according to title insurance companies particularly, will not be able to do anything without going to court and getting a conservatorship appointed. So that's why we put our real estate, particularly personal residences, into revocable trusts. Let me give you this code for the CFPs. The code is 4 digits, XH24. Kat, put it up in the chat. And if you would just email those 4 digits, XH24, to Caitlin, Caitlin at zelllaw.com, she'll make sure that you get registered for CFP credit today. And she just posted her email today. Now, last but not least, I almost forgot. I just want to show you real quickly before you all sign off today. Here's what's coming up on the next 8 sessions. 1, 2, 3, 4, 5, 6, 7, 8. Yeah. March 16th, we're going to focus a little bit more on some business issues. The top 5 things you should know or your client should know before selling their business. That's a fun seminar. I've done it before for private audiences and it's gone over really, really well. April 20th, we're going to do 3 ways to make sure your money goes to your heirs and not Uncle Sam. 3 primary ways. May 18th, which limited liability company, LLC, is right for you, depending on if you have a business, are you using it for investment purposes, are you using it for real estate, and how do we structure it? Because LLCs are so flexible. June 15th, understanding corporations. July 20th, understanding LLCs. Again, very popular topic with us because we set up on average an LLC a week here. Then we're going to do a deep dive into S corporations. I think the financial planners are really going to get a lot of benefit out of the summer sessions. We skip August, by the way. And then in October, we're going to talk about non-qualified deferred comp plans, what they are, how they work, how they don't work, and why they're so beneficial for businesses today. And lastly, we're going to talk about ESOPs. Employee stock ownership plans, which is a form of qualified plan that gets really special tax treatment. And I've done this session before in past breakfast briefings and lunch and learns. I think it'll be beneficial to go through it again. And then in October, we're going to talk about non-qualified deferred comp plans, what they are, how they work, how they don't work, and what's why they're so beneficial for businesses today. And lastly, we're going to talk about ESOPs. Employee stock ownership plans, which is a form of qualified plan that gets really special tax treatment. And I've done this session before in past breakfast briefings and lunch and learns. I think it'll be beneficial to go through it again. It says email Kat at Zell Law. I think it's Caitlin, isn't it, Kat? Or can either one get to you?
Either one will
Oh,
go to
good.
me.
Super, super. So no problem with that. So anyway, I really appreciate you all hanging in there today on our first Lunch and Learn of the year. It was an experiment. We greatly appreciate your participation, and we look forward to your participating in the future Lunch and Learns. And if you have anybody that you want to bring in to the fold to invite, let us know, and we'll get them on the list to extend an invitation to them next time. Without further ado, I'm Wayne Zell. Thanks for listening to the Lunch and Learn today. I hope you got something out of it, and we'll see you next time on Lunch and Learn number 2. Have a great, great week.